Okay, we're at 10 a.m. I would like to welcome all of you to the December Library Law Spotlight. This month we're doing something a little different. We are doing a question and answer on remote work. Remote work has been an issue I've been getting a lot of questions about. So I invited my buddies from Foster, Swift, Collins, and Smith. So Mike Bloom is here with us. Some of you may know Mike. He is an attorney with Foster Swift, and he specializes in employment law and I'm guessing also labor law. Is that right, Mike?
That's correct. Labor and employment primarily.
Okay. Y'all know Anne. This is Anne Suring. She is also with Foster Swift, and she specializes in municipal and library law. So we're going to go ahead and get started. Is that okay, Anne?
Absolutely.
To make sure that we have enough time. Okay, so we're working from a slate of questions, some of which I came up with and based on some requests I've gotten, and some were submitted through email. So I'm going to go ahead and just get started. So the first question I have is, can you explain the remote work requirement as mandated by the MIOSHA Emergency Rule 5.8?
Yes, I would. Before I dig into the MIOSHA rule, what I would like to do is talk a little bit about how we got to where we are with remote work. And I think that has confused a lot of people. And quite frankly, I think it's frustrated a lot of people. And the reason for that is that back in March, when the pandemic was first coming in, there was an order from the governor to shelter in place, where you had to stay at home. You could not go to work at all or anywhere else, unless you were an essential worker for a critical infrastructure business. And so we started with nobody can go into the office under any circumstances. And then the state of Michigan started rolling out the Safe Start program. And the Safe Start program was designed to get people slowly back into the workplace after the shelter in place order or stay at home order was lifted. And that, as I think everybody's familiar with, was done in phases. Started with phase 1, nobody could go anywhere, and phase 6, to where there's no restrictions right now. For the most part, Michigan's in phase 4. Northern Michigan actually went into phase 5 for a little bit, but got rolled back when the second wave came in. So what that did is it got the mindset of businesses, including libraries, on now we have to focus on reopening, getting employees back into work, reopening, but doing it in a way where we can protect people's health and safety. And so that's where the return to work policies that were being implemented came in. Is the idea then was get people back into work safely, and you have to have precautions in there, cleaning, self-quarantine requirements if certain things happen. But the mindset at that point was, let's get people out of their own homes and back into the workplace. What happened then was we got into the second wave, and the governor's executive orders were ruled by the Supreme Court to be invalid. So those all went away. And the question was, what's going to happen to protect everybody's health and safety when they get into the workplace? And MIOSHA issued in October, they issued the emergency rules to fill in for where the governor's executive orders left off. But it took a different approach. Under the MIOSHA emergency rules, particular Rule 5.8, it sort of twisted the thought process. Instead of let's get everybody back to work, but do it as safely as we can, what MIOSHA did is they said, wait a minute, at least temporarily, what we have to do is we got to change that mindset. And the mindset has to be that everybody stays at home if feasible. And that concept was a little bit under the governor's orders, but I think a little bit looser standard and less enforcement power behind it, I think, or at least it wasn't being enforced by an agency dedicated just to enforce this particular rule. MIOSHA is, and MIOSHA shifted it to say you must prohibit or prevent employees from coming in to work unless you can show, as the employer, that the work that you want the employee to come in to perform cannot feasibly be done at home. So I think the focus shifted, and certainly the burden on the employer shifted. So that's what the MIOSHA emergency rule says, is that you must, by policy, prohibit employees from coming in unless you can meet the burden of showing why what you're having them do when they come in cannot feasibly be done at home.
So when they say feasible, when the rule says feasibly, what is feasibly?
Well, that's a good question, because like I just said, it's a different term than the governor had used. And feasible, in the Health and Human Services order, which predated MIOSHA, they used the terminology physically impossible. Now, the Michigan Department of Health and Human Services order has been rescinded 3 times now. It started in October, early October, then got updated as things went on, and the most recent one is December 8th, when the governor extended for a couple of weeks the HHS rules, which cover primarily face masks and gatherings. Now, gatherings is across the board. Gatherings is, any place, retail. It affects libraries with the restriction of 30% if you're going to be open. So that's much broader than employees coming in. But with respect to employees, the Michigan Department of Health and Human Services was using the terminology in one of their FAQs that said physically impossible to have that work done. Now, that would be a really, really high bar if that's what's to be used. And for example, if you're a Ford Motor Company and you have an assembly line and you have cars coming off, can you have that employee do that work at home? That's physically impossible. You can't do it. You have to be there because that's where the assembly line is. I don't think that's going to be the standard that's going to be applied. I know it's not with MIOSHA for a number of reasons, but most importantly, in the most recent MDHHS orders, it refers specifically, it pulls out workplace requirements out of their order. And then in one of their FAQs, they say the reason they did that is because it's covered under the MIOSHA's emergency rules. So they're deferring to MIOSHA, even though their FAQ and that physically impossible standard is still on their website. I think it's been preempted by the MIOSHA emergency rules. So what is feasible? And MIOSHA did issue an FAQ on this point. It said, what will they accept? And in their FAQ, they said that first they want a policy. They want to know that you are prohibiting employees to come in unless it's not feasible. And then with respect to feasibility, they said that it's the employer's obligation to identify the positions and classifications for the in-person work and why they need to be in work. So you have to look at the duties. It can't be across the board that anybody in a particular position, everybody in that position has to come in or can't come in. You can't do it by category. You got to do it by job duty. So I recommend that employers look at the job descriptions as a starting point. and identify the duties. And then what MIOSHA wants is to look at those duties and then have an explanation as to why those duties cannot be done at home. And according to MIOSHA's FAQ, they're not going to micromanage that. They specifically say that they will allow the employer to use its discretion as long as they don't think it's a circumvention and not taken seriously. So if you can identify why somebody needs to come in, because the way this particular library operates, that can't be done at home, MIOSHA is going to accept it as long as you have an explanation. That I would recommend you have a document somewhere that explains why you're requiring people to come in. For example, if you're having curbside requires various tasks to get that material out to the patron in their cars. Could you have somebody, when the patron pulls up curbside and texts, I would like this and this and this material, and then you call the employee at home 45 miles away and say, okay, this is what they need, come in, you got to come into the library, you got to find it, and then you got to take it to this patron, and the patron sits there for an hour and a half. Is that feasible? In my opinion, absolutely not. I think that type of explanation is going to be absolutely accepted by MIOSHA. The other thing is sometimes you need in-person face-to-face contact. You may have, if you're open under the 30% rule, you're going to have some people in there. You're going to have a service desk. The patron goes up to the service desk. I don't think it's feasible to say, okay, there's a telephone call, the staff at home. I think it's reasonable to say that person has to be there. Why? Because face-to-face contact with the patron that needs help is critical and cannot be done at home. So I think those are the types of situations that MIOSHA, if they ask, is going to look to see if you thought that through and have an explanation. If you do, I think they'll accept it. If you say, well, it's more efficient to have them in here, or it's easier for the library, or it's less costly because I don't have to worry about the equipment or whatnot, MIOSHA is not going to accept that. So it's got to be the duties that have to be performed and why the library thinks that that's important enough that it be done in person. And MIOSHA, I think, will say, okay.
So if you have, in the library world, a lot of times you have positions where you may have, say, reference or circulation staff who have to be on the desk a certain amount of time, say a certain part of their shift, but then the rest of their day, they're not. They're at their desk or they're, working. To what extent does the employer have to say split schedules where they say, okay, you're on the desk, you're in the building, that period, but when you're not on the desk, you're home?
Well, that is something MIOSHA is going to definitely require, because it's only the duties that must be done in person that you're allowed to bring the person in for. But I think there's going to be a situation of really the timing. Is if it's a situation where you don't know when the patron is going to need assistance, just by way of example, you have a certain staff assigned for the service desk, and you're going to make sure that the patrons are serviced, and to say, okay, you need to be there when that patron needs help. Would it be reasonable for that person to be home and come in when that the patron needs help? I don't think so. The person has to be there. So in that situation, if the primary duty assigned to that staff requires face-to-face contact with the patron, if it arises, then I think the fact that there's no patron at that moment is asking for help doesn't preclude that employee from going into the back room and doing other duties or whatnot, because it would be impractical to go back and forth every time somebody needs help. But what you might need to do is say, well, why does every person that potentially could be at that service desk in the library at the same time, why can't you stagger them? And I think that that's going to be an issue you're going to have to figure out, is how you're going to staff those jobs that require in person, so that not everybody is in the library at the same time. You can stagger them so the minimum necessary to meet the needs of the patrons in the library are still met, but not with everybody sitting there on the what if.
And Ness, we have one kind of pertinent question in the chat here. If many libraries have, they don't like to leave the library staff with only one person, even very small libraries, from a security standpoint. So if you have somebody at the service desk and you have another person in the building kind of working as backup, it would seem to me that that would be an acceptable, security would be an acceptable reason to have two people in the building, even if
I would
both
agree
are
with
on the desk.
I would agree with that. And, on that point, keep in mind that MIOSHA as an agency's principal purpose, if not only purpose, is for the health and safety of the employees. So for MIOSHA to say we are not going to allow the security, the safety of an employee to be an issue, I can't see MIOSHA doing that. To say why one versus two, you could say because what we can have is, the two people can share responsibilities. So you get, on the schedule, and you'll have, maybe not minute by minute, but you're going to have, one person at service, that's the other person not, and then you switch to, for relief or whatnot. So that's one issue on the scheduling, and I think that's appropriate to rotate two. If you tried to do a 3 or 4, I think you'd have a problem. But I think that's reasonable, and and it's safer for both employees to do it this way than to have one person put in harm's way by working alone. I think that certainly would be considered reasonable and would be accepted.
And I'm going to go to the chat again, just because there's another relevant question here, and then we'll continue on the plan questions. What if the switching around of schedules to accommodate, people who work, say, part on the desk and part at home, interferes with a union contract? How does union agreements intersect with these MIOSHA rules?
That would be something that would have to be discussed with the union. It would be mandatory, subject to bargaining, because it goes to working conditions in the workplace. But the unions are also going to be responsible for complying, or making good faith attempt to comply with the MIOSHA emergency rules. So I don't think that a union would put itself in the position of saying, nope, we want everybody in here, we don't care what MIOSHA says, because an employer never needs to violate the law just because it has obligations to negotiate with the union. You can't negotiate into collective bargaining agreements, illegal provisions. Those would be null and void. Because the law is going to supersede them. So here, I think that how you're going to do it would be something you would have to discuss with the union. But if it's a rotation, or if it's how many or whatnot, or who, the union may say, well, we want to do it by overall seniority. You might say, well, we can't do it by seniority. We need to do it by classification, and then within classification, ability or whatnot. The union may have the right to sit down and talk about that, but they would not have the right to interfere with the library's compliance with the emergency rules.
Okay. When do you think the rules will be done? When do you think their emergency temporary rules, are they connected to the emergency order? Because right now there isn't like a governor's emergency order, or state of emergency. So how long are these rules active for?
Well, these rules, and we're talking two different rules at the moment. We're talking about the MDHHS order, and we're talking about the MIOSHA emergency rules. Both were issued with emergency authority. And that's why they're actually called emergency orders or emergency rules. And the significance to that is, if a government agency implements regulations, they have to follow the Administrative Procedures Act, which requires notice and an opportunity to comment, and then implementation, and then that would become law until they're rescinded. Under the emergency rules, they can take effect immediately without the notice posting and obtaining the comments. But with that right to implement immediately comes a mandatory maximum period of time when it can take effect. The MDHHS rules originally were to expire December 8th. They were extended by when the governor, extended everything for a couple of weeks. So that's why the MDHHS rules now are the ones that are most effective are December 9th. So if you're looking at MDHHS orders of, for instance, November 18th, which was a prior order, that's been rescinded in favor of the December 9th order. And that, by its terms, expires December 20th. But you have to be careful with that because that's only the requirement on gatherings. And again, that order ties into the MIOSHA emergency rules. So even though the MDHHS order expires December 30th, unless it's going to be extended, the MIOSHA rules under their emergency authority had a maximum of 6 months sunset. And those were implemented on October 14th. So those, unless rescinded earlier, those will be in effect until May 14th.
And it seems that there's a governor's press conference today, so I'm wondering if she's going to extend that MDHHS.
Yeah, you don't know. And yeah, I will throw in my disclaimer right now, is depending on what the governor says, if everything I'm talking about this morning is irrelevant, I apologize. I don't think it's going to be, but things have changed quickly.
I hear you. And that order.
I think Ann has a comment.
I was just going to say, Claire and I were in the middle of a presentation once when a new order was issued. So at least you have like a couple good hours left on this advice.
That's right. The order came down in the middle. The MDHHS order expires the 20th, not the 30th.
Yeah, the 20th. That's correct. Yeah. If I said 30th, that was mistake. It was the 20th.
There's a so when you look at, again, the MIOSHA rules, is there, as far as remote work goes, is there a different way you look at exempt versus non-exempt personnel with purposes of remote work, like who can and cannot work from home, schedules while working from home? You have a lot of times when, like me, for example, I use myself as an example. I'm working from home right now because the state employees are working from home until at least March. I'm exempt, and if I have to go pick up my dog, or if I have to take the dog out for a walk in the middle of my work day, my schedule is fairly flexible as someone who's an exempt worker. To what extent would that apply, exempt versus non-exempt, and as far as tracking of the hours and time worked?
Well, the designation of an employee as exempt or non-exempt would not be a basis for determining under the emergency rules that work from home is not feasible. That would not be permitted. That, I said earlier that you can't have broad categories that apply to everybody in that category. It's got to be more nuanced or detailed than that. So to say all exempt employees are treated one way and all non-exempt employees are treated a different way, that is not permitted. What I think does come into play here is that exempt employees, for the most part, for the libraries, it's all the white collar exemptions, either the administrative employees, which are the department heads, or supervisors. And so it's your higher level employees that have independent discretion to get the exemption. from the requirements under the Fair Labor Standards Act. So when you look at that, it's more likely, I think, that in-person work for an exempt employee would be necessary because of the higher level of responsibility that those employees have for the operation of the library and the independent discretion that they must exercise. For instance, supervisors, if there's staff in and you have a supervisor, can a supervisor supervise from home? Probably not. If the employee is, in the office, they need a department manager there to say you're going to be at home and wait to hear if there's a problem, and then you'll deal with it, or monitor it through, Zoom or whatever. I don't think that would be a practical way to exercise your or be responsible for your supervisory duties. But if those staff are not in the library, to say you have to be in the library because you're supervisor, there's no staff in there at that time. So that's not going to work. So you have to look at exactly what the duties, again, okay, you're a supervisor, that's fine. Why can't you perform your supervisory duties at home? Well, because my staff is, in the library, or I'm a department head and there's certain responsibilities I have, and that requires that I am in the library for certain to take care of certain responsibilities. If I'm IT and the server is sitting in the library, take the whole server home and bring it back would not be feasible. So you have to look at it that way. And I think it's more likely that you're going to have a good explanation as to why exempt employees, at least in certain circumstances, need to be in the library, but not across the board, certainly. And Claire, your comment about schedules is a very interesting one because, by law, exempt employees, get a salary, and they get the salary for doing whatever work is necessary during a day. And if they do it, at some hours and not other hours, for the most part, the law says that's why they're exempt. That's their discretion to determine when they're needed, when they're not. As long as they get the work done, you don't micromanage the exact times they're working. For staff, that at least when they're in the library opens at a certain time, it closes at a certain time, you have shifts, and the employees have to comply with that. Is that going to be necessary when they're working from home? It may be, it may not be. If they are working from home and they have certain tasks that they need to get done, and the hours that are assigned to them while they're in the library, because the library is open and you need to staff it according to the shifts and whatnot, does that really apply at home? Maybe not. But what might apply at home is that they have to have conferences with the department head or the supervisor, or maybe the director at particular times. During particular times, they have to be maybe available for calls, if they come in or whatnot. So you need to know that the staff is going to be there during certain periods of time. That you would have certain amount of discretion to control. But if somebody wanted to work earlier than normal, later than normal, to be able to work from home, maybe they have a child at home and they say, well, I'm going to need, from 2 to 4, who normally watches my child can't, so I have to, but I'll work later. I don't think it's enough to say, well, that wasn't your schedule at the library, so you can't do it at home. I think you got to be a little more flexible than that.
If you have, and there's again a question in chat here that, so if you have a library that is has multiple levels of management. So a lot of libraries have, you have the director and then you have some staff. But if you have a bigger library where you have department heads and then you have a director, so to what extent would it be that, every supervisor would be in the building? So the director and every supervisor? Or is that just determined by which employees are in the building?
I think to say every manager and every supervisor has to be in at the same time, I think would be a tough sell if you get audited by MIOSHA. Especially since under the gatherings limitation under the MDHHS right now, you're at 30% capacity. If you're at 30% capacity, why do you need 100% supervision and department heads in for 30% service to patrons? I don't know that you're going to have a good explanation for that. I think what you do need to say is, okay, for this particular department, it may only be 30% of the patrons that come in here, but the responsibilities are much greater than that. But you're going to have to be able to say what they are. You're not going to be able to say, well, they're a supervisor or manager, so they all have to be here. I think that's the type of thing that MIOSHA indicates in their FAQ they're not going to accept.
Okay. So there are many libraries that I'm getting questions about or I guess reports from where the boards are not permitting remote work. So if in a situation where you have a director who is saying, you know, I know it's required, but my board doesn't see the reason for it. They don't believe in remote work. They think everybody who's at home working is not working. What is a good discussion that a director, a good explanation that a director can make with their board to convince them that they really have to do this?
I would start with the MIOSHA Emergency Rule 5.8. The language of that rule is pretty clear, and it says you must have a policy that prohibits employees from being required to work in the library. And then you can go from there. To say that we as a board disagree with the law is really not a good position to be taking. So I think that there has to be discussion as to what the law is, because, you know, the MIOSHA emergency rules are an agency of Michigan with enforceable powers that are currently in place. And there's the city, and I don't think it's any secret because they're public information, but the city of Port Huron just got tagged. They got cited because what happened was somebody went into a workplace, which they had the right to do. They looked around and they saw that the emergency rules were not being enforced, and they issued a citation. And the citation, they issued what's called a serious citation. And with that comes a penalty. In that case, I think it was $6,300 or some amount. They could be $7,000 per violation. And so I think that a discussion, and I don't know if the director is the right person for this discussion, but the discussion is you can't simply refuse to comply with MIOSHA's emergency rules unless you're willing to take the risk of a fine of $7,000 for each violation. So I think that some people aren't looking quite at the potential liability. They're looking at their views on preferring people to be, working, in the workplace. Mm-hmm. And that's understandable. That's fully understandable. It's more efficient. It's, in many respects, probably more productive. It's easier to manage. It's probably better, at least for the old school people, if I can use that term, with my hair. It's something you get used to and you want. MIOSHA doesn't care. They're going to say none of that applies. You follow our rules, explain why you can't, or here's your $7,000 ticket.
It's interesting that you said that because one of the times I got this question, I've gotten it from a couple people. I actually sent the director a copy of that Port Huron citation and said, "Show this to your board because this is a big deal."
Well, if you look at it in a different context, and I don't think this is going to happen in the libraries, but just to show you how serious MIOSHA is about this, is the restaurants, in-person dining. right now need to be closed. And a lot of restaurant owners think that that shouldn't be the case. They're being picked on, it's unfair or whatever. The owner of Andiamo's, Joe Vaccari, actually talked about having open rebellion on that and staying open across the board, because what's the governor and the state going to do if everybody refuses to comply with them? Well, that didn't play out very well for them, because what MIOSHA did is, for these restaurants that were showing resistance, they sent investigators into the restaurants to see what they saw. They didn't like what they saw, and they yanked their license to operate. So the state definitely has power.
In order to permit an employee or to encourage employees to work from home, can an employer require an employee to take on different tasks than they normally do?
Generally, yes. The employer has a fundamental right to determine the tasks that employees are going to be required to perform. But there's going to be some nuances, some variations to that. You do have a job description, and the job description spells out what the people should be doing. Most job descriptions say, or other duties as assigned. And that's generally understood, that the employer, the supervisor, has a right to tell the employee what they're going to be doing. The employee has an obligation to do it. If you don't, that's called insubordination. But you have to be a little bit careful. First of all, in the union world, that is going to be a bigger problem, because in the union world, you probably don't have the right as the employer to unilaterally change the job duties of employees, in particular classifications. Those classifications are negotiated. There's rates negotiated for them. So if you start changing those, you're going to have problems with the collective bargaining agreement. You're also going to have issues if an individual, for example, under the ADA, if somebody has a disability, and if they have a disability and they are unable to perform certain duties that are not essential duties for the regular job, under the ADA, you cannot require an employee to perform non-essential duties if it's and not doing that as an accommodation for the disability. That would be required under the ADA. So I would say, within reason, yes, you can expand what they would normally do. We don't have all of the work that you generally would do, but we're paying you and we're shifting what you are required to do. Within reason, I think you have latitude to do that to a significant extent. But you do have to be careful if you're getting into issues where the employees cannot physically perform them because of a disability, because of an obstacle in the union contract, or you also have to worry about is the employee really capable of performing, and then you might have negligence issues creeping in.
Okay. And the next one's kind of an interesting one. So if you have a workplace where the employer is already involved in remote work, some people are already working from home, and the employer already has it kind of worked out, and you have employees that now have to quarantine because of exposure, can the employer require, when they're in quarantining, can the employer require them to remote work?
It depends on their abilities to do that. Because if they're in self-quarantine, there's a number of different reasons why they're being quarantined. Mm-hmm. They may be self-quarantining because they were in close contact with somebody. They have no symptoms. They have no issues. They have no problems that they're aware of. They're perfectly capable of doing whatever they're going to do, but they're self-quarantining. So in that situation, the answer is clearly yes. At that point, it becomes a pay issue, because if they're capable of performing work, even though they have to do it at home, and they won't, and you don't want to treat it as a disciplinary measure, and you probably don't, because COVID-related reasons, I would not recommend terminating right now for all the protections that are in place. But you don't have to pay them, because you don't have to pay them if they can work, they refuse to work, they wouldn't get paid, and in those circumstances, they probably wouldn't be eligible for unemployment either. So you can't simply refuse to work, even if you're capable and work is available, and expect to get money somewhere. It gets a little more complicated if the person is self-quarantining because they're sick. And if they have symptoms of COVID, they're incapable of working because of it. They would not be able to come in normal times to work because they're too sick to come in. Then to say, you're home, so you have to work, just, I don't care if you're sick, that wouldn't be acceptable.
Okay. I have a couple other scenarios under that kind of question. One is if you have an employee who is a member of a vulnerable population. A lot of times this comes into play because you have employees who are of an advanced age. And I've had people call me and ask if they can be told to work from home to protect themselves so that the library doesn't have to worry that they're going to get ill.
Yeah, there's two sides to that coin. One is allowed because of that, and the answer is yes. Required because of that, the answer is no. The EEOC has a guidance out, and one of the issues they addressed is specifically that if somebody is in the higher risk category, and because they're in the higher risk category, they must work at home. The EEOC says that's discriminatory. If they can come in under other circumstances, they're not at risk of bringing COVID into the workplace as a direct threat to other employees or whatnot. They're simply at home, particularly if it's age, because they're in the higher risk category. The only reason they're in the higher risk category is because of their age. The employer says, but we don't want to take that risk. If you do get COVID, it's going to be worse for you, and we're going to make you work from home. That would be a violation of Title VII.
Okay.
Or of the ADA is what it would be a violation of.
And this last one's kind of a weird one, but I'm starting to get questions about employees who are posting on social media that they are out and about, particularly maybe engaging in activities that are currently frowned upon or prohibited, or not wearing masks or in large crowds. And employers are seeing this on social media. And the question is, can I require this person to work from home because they're engaging in behavior that's risky and my other staff don't want to work with them?
Yeah, that question has a lot of layers to it.
Yes.
Definitely does. And it gets into sort of back to the question of how much can an employer rely on or use social media for in supervising its employees. Mm-hmm. And I think everybody knows that employers can jump onto social media. They can look to see what applicants or employees are doing, have been doing, and whatnot. And I get a lot of questions of, is that permitted? And my answer is always, yes, it is permitted, but be careful what you wish for. Because now you're going to get information that you might be better off not knowing. So the first question I guess I have here is, what exactly does the library, the supervisor, or the director want to do? And what you want to do is monitor employees' off-duty conduct through social media. Do they have the right to do that? Yes, as long as they don't go too far. There are some privacy rights by statute on what you can and cannot do on social media. For instance, you can't require employees to give you access to their confidential pages of social media and whatnot. If you do that, that's a violation of Michigan law. So you do have certain privacy issues, but leave those aside. It's public information. In that public information, you know that somebody was over the weekend at a bar. You know that that bar has just happened to be in East Lansing, Michigan, and happened to have 75 or whatever positives in one night. Can you, or do you have to ignore that? No. No, you can react to that. So if you have information that you either reached out to find on your own or was brought to your attention, which, in that situation may well happen, I think you not only have the right, but probably an obligation to do something about it. Because if you allow that person now to come in, knowing that they have been or likely have been in close contact with COVID-19, now to say you can't come in for 14 days because I'm not going to allow you, take the risk of allowing you to bring that into the library would definitely be permitted. How much further you go beyond that, I think, yes, you have the right to snoop, if I can use that term, but I'd be careful on how far you go beyond the issue of, I know that they are at risk of bringing COVID-19 into the library, and I'm going to safeguard my employees by not allowing that to happen. You certainly have the right to do that.
Does the employer have to supply the equipment for an employee to work from home?
Generally, no. And I say generally no, because that is an issue that comes into play with under the prior governor's executive orders. It started out with, is the employee capable of working from home? And that's where I first saw this question coming in. And the answer then was, well, it really depends on, do they need internet access? Do they have internet access? If the employee has no internet access in their house and internet access is required for them to do their job, would the employer have to pay for that internet access? And I think the answer clearly is no. Now,
can I pause? There was an interesting question in the chat on that basis. I think you've answered the question about internet access. What if the library lends out hotspots? So the library owns hotspots they lend out. Are they then required to use those hotspots to take them out of circulation and give them to their staff?
They could. They could, because when you're looking at this, the question is, I don't know of anything that requires a significant expenditure of funds to allow people to work from home. But the MDHHS order that has now been, I think, preempted by MIOSHA, but that order specifically said that an increase in cost is not a basis for requiring somebody to work from home. So I think there's going to be a level of reasonableness there. And so and this is going to be really an accommodation issue. Right now it's a MIOSHA emergency rule order, but it's really an accommodation issue. And with any accommodation, or work from home as an accommodation, reasonableness steps in. So you have to determine what is available, what would it take to make it available, and then evaluate it along those lines. So you don't need to, install internet for the person. If you have available hotspots, as Ann said, would it be reasonable to allow them to use it? Or is that not reasonable because those need to be used, kept someplace else for other purposes? I don't know the answer to that. It's probably going to be depending on how each library works. But if it is something that is available and it would not cause an undue burden to the library to allow it, I think it would be required. The other issue that creeps in here, though, is a lot of libraries and a lot of businesses have employees use their own equipment. If you have them using their own laptops or iPads or whatever, the question becomes, how secure is that communication? And as the library, you have obligations to protect privacy. And so the question becomes, if you require somebody to use their own personal laptop and they have access to patron information and that is not secured and that gets hacked, could the library be held responsible? I think it could. So what I recommend is, and I'm not an IT person. I know how to use a computer, or at least to the extent that I know how to turn it on. But I would recommend that you make sure that you have IT involved in this and make sure that you have appropriate security in place to make sure that confidential patron information, as well as employee information, is not inadvertently made available in violation of privacy rules.
If
I don't know, Ann, you've had this issue too. Do you have any other comments on that? I know our office has had information or questions, and I think we've actually put on a seminar on cybersecurity issues and whatnot for the computers. Do you have any other comments?
No, I do think though that that the library privacy aspect has to be taken into account, and so I do think that as long as you demonstrate the appropriate security measures are taken, because we as lawyers have we have confidential information that causes an issue for us if we take it home. So for example, I think the library community understands that if you're an employee of, we talk about this with library privacies, if you're an employee and you go home, you can't tell your spouse, kids, significant other, friends at, around cocktail hour about what happened at the library, even if it's really interesting, if it reveals confidential information. And so we also, one of the things that was told to us is that, be careful about printing stuff out. You shouldn't be printing stuff out and leaving it around your house if it contains confidential patron information. So just be really cognizant of that. Treat all that information as if a stranger was in your house, and would you show that to them? That the same rules should apply to friends and family who come to your house. So just be aware of that.
All right. Now that's an excellent point, and that gets into what is reasonable. But I had a lawsuit in federal court a couple of years ago where work from home, not under COVID, but as an accommodation, was the issue, and it went to trial in the federal courts. And one of the issues was the employer said we can't allow work from home for a number of reasons. One was the privacy issues. And it's that this information was highly regulated, under the banking rules, and we couldn't take the risk that this person would print out applications with confidential information that other people in the house would see, et cetera, et cetera. And one of the issues became, well, could you control that? So that comes into play here is how do you control it? How do you know? And I think you have to start with making sure your policy requires confidentiality be maintained. You take certain precautions to make sure employees aren't ignoring that. And you could, this was with respect to, how much time are they working? What are they doing? How do you know what's going on or whatnot? I would recommend having periodic requirements that the employees participate in Zoom conferences, and the Zoom conference will allow you to see a little bit of what's going on, and then you can even say, well, now okay, let's just talk about how you're handling this private information. I'm in this room and nobody comes in when I'm done, and I understand the policy or whatnot. So if you do it through policy, you have the requirements, and you don't ignore violations, I think you're going to be found to be reasonably safeguarding privacy information. but you can't simply say, I'm concerned that that might be confidential, so come on into the library. I'm not going to let you work from home. You have a higher requirement to safeguard it.
If you have an employee who is being accommodated under the ADA pre-COVID, and maybe those accommodations apply to a certain arrangement of their workspace and maybe a particular chair, if they are working from home, is the employer obligated to provide those same items at home?
Probably yes, because the the working from home, and this isn't just COVID related. This is for any remote work, and some employers before the pandemic have had remote employees for a number of different reasons. You might, for instance, with sales or whatnot, some employees at certain levels, work from home or work someplace remotely, without regard to the pandemic. And MIOSHA has been aware of this for quite some time, and they have made it clear that it doesn't matter where the employee works. The requirements for providing a safe work environment apply regardless of where they work. And so that is also going to be the case under the ADA. So if an employee is disabled and they require an accommodation to work in the library, and now they're working at home and they need that accommodation, would it be an undue burden on the library to provide that same accommodation at home? And if it's a chair, I doubt it. You could get to the point where accommodations can be made in the workplace and not at home, but that's really going to be a cost issue, I think. And when you're in the ADA land and you use cost as a basis for refusing to provide an accommodation, you have to show that the cost is sufficient enough to cause an undue burden. And that's a pretty high bar. That's a pretty tough standard to meet. So for the most part, I would think that, you would need to provide that same accommodation, particularly, and if it's a chair, I don't know if this is going to be available with everything, but can the chair be taken home? And if not, why not? Maybe bringing it back and forth every day might be a little burdensome, but relocating what they did used in the office into their home, to say that's unreasonable, you might have a problem explaining that.
Okay. Continuing on the ADA question, if you have an employer or a library that pre-COVID never permitted work from home, felt that it was just not feasible in a library setting, and including as an accommodation. And then you have COVID and everybody's had to work, from home, at least for a particular amount of time. And the library has found ways to have people work from home. At the end of this COVID period, so assuming that the rules are done and the MDHHS order is done, does the employer have to continue to permit remote work, including, would they have to permit it as an ADA accommodation if they had not done that before?
Yeah, and I've seen that. That question's been percolating for quite some time, so much so that the EEOC addressed it. And the EEOC has made it clear that just because you provided an accommodation of work from home during a pandemic doesn't necessarily mean that you have to do it once the pandemic passes. But I think what they're really talking about is that during the pandemic, you are providing work from home pursuant to first governor's executive orders and then MIOSHA's emergency rules that require work from home without regard to the issue of disability. Once we're post-pandemic, now the only work from home issues are going to be under the ADA. And so that question is going to get considerably limited because there's not every employee is going to be entitled to say, well, I worked from home before, so now I get to now. No, you don't. Those rules are all gone. But now it's going to be a little harder to say, I cannot allow work from home for somebody with a disability if you've already demonstrated during the pandemic that that is possible. Now, post-pandemic, things may change, so I think you have to look at it fresh then. And if you can say, no, why it would not be reasonable post-pandemic to allow disabled people to work from home, that is still available to the employer. But I do think it's going to be something that's going to require a little more detailed analysis, probably a stricter burden to meet.
If you have a remote work policy and it's part of your pandemic plan, does your remote work policy have to be a separate plan, or can it be integrated into your pandemic plan?
It can be integrated.
Okay.
Yeah, the FAQ that the MIOSHA issued on that addresses that specifically. The reason why you generally see it as a separate policy is because the requirement for a plan, a preparation, and or the response and preparation plan, that's been with us for quite some time. That was required under the governor's executive orders. And so most employers, and I think a large number, if not most libraries, have already had preparedness and response plans in place. So, MIOSHA didn't say you have to redo them, reissue them, but what you have to do is supplement them with a remote work policy, because we now have made that a requirement. But they say specifically that if you want, you can reissue the preparedness and response plan and incorporate the remote work into it. That's permitted.
Is the employer liable for workers' comp if an employee is injured at home while working?
Could be. Definitely could be. And that the question becomes under what circumstances. But under workers' comp, just like under MIOSHA, workers' comp says if you are injured in connection with work duties, that's a workers' comp claim. And workers' comp does not say that's only if the injury occurs at the employer's place of business. It's wherever the injury occurred. So you see workers' comp claims before the pandemic, employees coming into work and they trip and fall in a parking lot that's not the employer's coming to work. And is that covered? There's a lot of litigation on that. Workers' comp has made it clear that we don't care where the injury occurred. We want to know, was that injury in connection with the work? So that would apply at home. And the question becomes, what can you do to safeguard that? And there is no obligation, and workers' comp is not going to require an employer to do regular inspections. Neither is MIOSHA. They're not going to require regular inspections of the workplace, and they're not going to go in, for the most part, to the workplace to monitor it. But they are going to say, did you take reasonable steps to ensure that the employee was in a safe work environment? And if you were, it's kind of a negligent standard, or a knew or should have known. You should have known that there was a hazard. You did nothing about it, and the person got injured and they got injured because of work duty. That probably is going to be workers' comp. So what safeguards can you take? If you look at the remote work policy that I put together, or that there's a number of them out there. You can either get them from us, or you can get them off the internet or whatnot, but they all have certain elements to them. And one is that you should have in there what is required for the employee to work at home. And mine specifically addresses that you have to have your work area in the home meet those standards.
Okay. if an employee is working remotely, can the employer regulate where the employee actually is? For example, if an employee wants to hang out at their relative's house or go to their cottage, is that can the employer say, no, you have to be at your house?
I don't know the answer to that question. I saw that question on your outline, Claire, and I was thinking about it a little bit. And remote work generally means working anywhere outside the regular workplace. And the MIOSHA requires a remote work policy. So if you look at that, it's a policy that you work remotely wherever that may be. And so there's people that have cottages up north or whatnot. And, if they want to go up there and work there instead of working in their house, is that something that MIOSHA is contemplating? I think they are. Because from the library standpoint, do you really care if they are in their house in a particular city near the library, or if they're up north? Doesn't make a difference. And the answer to that, doesn't make a difference, really depends on your needs. If you need that employee to be close enough to come in at certain times, then working in the Upper Peninsula might not get it. But if it's something that can be done 100% remote work from home, then maybe it doesn't matter where they are. But allowing them to continue to go back and forth, maybe they don't have the same situation. Maybe they have Wi-Fi in their regular home in the UP, maybe not or whatnot. Those factors are going to come in. There's also going to be issues depending on exactly where they're working. There could be tax implications, not so much for the library, but for the employee. Because if they're working, for instance, if they're working out of state, they might be taxed twice. Okay. So things like, so issues like that creep in. That's why this is not a real simple question. But for the most part, I think that what the library should do is work with the employees, say, okay, where are you going to work? We got to make sure that you're wherever you're going to work. And we're not going to tell you it has to be one specific location. Let's talk about where you plan on working and why, and then we'll see if it's feasible.
Okay. And the last question I have before we open it up, it is 11:08, is going to step a little bit outside the remote work area, but this is a question I have been getting a lot. And that question is, can the library require staff to get the vaccine when it's available? Yeah, I have almost like a cut and paste answer I've been sending to that, but which is very non-committal.
Yeah, no, that's sort of the question of the day right now with vaccines being approved. I don't know, Ann, you want to take this one?
I think the jury's still out on that, because I think you're going to, and plus, from what I understand, there's so many exceptions to the rule. You got, people who don't want to take it for medical reasons and other things. It's not going to, there might be a policy decision about whether the risks associated with mandating it are worth the benefits that you get from it. I mean, that's kind of how I'm looking at it right now. But it's certainly not, from what I understand right now, it's certainly not a clear cut yes, no, answer. There's so many, things that are concerning to me that I would seriously, I think that there's going to be more information as the vaccine rolls out. But right now, I would seriously get legal, about your own personal situation. Depends on how many, maybe you have 2 employees and they both want to get it and they have no, medical issues, and it's going to be different for everybody. But that's an open question right now.
That's pretty much the answer that I've been giving out. There is some research that people are alluding to from the flu, where an employer can, and there's some industries that require, for particular reasons, certain things like hepatitis vaccines. But everything I've read so far says, you know what, it really isn't worth the what Ann says, it isn't worth all of the hassle because there's a lot of accommodations you have to prepare for. And you should just put your time into trying to encourage your employees to take it.
Right. And yeah, this yesterday, because this vaccine was just approved, and yesterday the EOC updated its guidance to specifically address vaccines. And, with respect to the exceptions that Ann talked about, there's really two. One is disability. If you cannot safely get a vaccine because of a disability, you cannot require that the employee have it. That's not a new requirement. You also have with vaccines a religious accommodation that comes in under Title VII, which you probably need to respect. So those are the two big carve-outs. In Michigan, at least with respect to the mandatory vaccination rules for children in school, when you have to, get your child vaccinated to put them in school, unless you get an exemption. And the exemptions there are disability, religion, and they also have a personal opposition provision where if you are personally opposed to vaccines, for whatever reason, personal to me, I don't trust them, I don't like them, that is permitted under Michigan law, at least with respect to the schools. Would that apply to employers? Probably not. But I think it's something that any employer that wants to implement mandatory vaccination policies should think about. There's a lot of chatter out there on the internet, primarily from nationwide employment attorneys that are saying there's no prohibition against it except for these two limited exceptions. And yes, employers have an absolute right to do it. Maybe not, but that also gets into the be careful what you wish for, because I put my employment lawyer hat on, and whenever you implement a policy, my question is, are you ready and willing to enforce it? And I say that because the surveys are coming out that anywhere from 30 to 50% of people surveyed say that they will not get it. So if you implement a mandatory vaccination policy and your employees refuse, even say 20% refuse, are you prepared to fire 20% of your employees? And if you're not, you really shouldn't have a policy requiring it because you're not enforcing it. Now you're on disparate enforcement that's going to walk you into trouble.
Yeah, and I think that the sort of the set of facts that I worry most about are what Mike said, be careful what you wish for. I think that, but there's lots of facts that we're going to have to deal with. One of them being, there's people that don't want to come into work now because they're afraid of COVID, whether that fear is valid or not based on but they are, genuinely afraid. Those people refuse to come back into work. You might have a group of people, maybe some of the same people who are, do not want to get the vaccine and now refuse to come back into work because, don't want to get the vaccine and then also don't want to come back to work. I think that's going to be one of the challenges that's going to be faced with every employer, coming up.
Yeah, I agree. Okay, it is 11:14, so I'm going to open it up to questions from everyone. We've covered pretty much everything in the chat. Does anyone have a question that they would like to ask?
I have a question. This is Barbara at the Milan Public Library. There was a question in chat pertaining to if you have required an employee to stay home because you discovered they were engaging in risky behavior. There was a follow-up question. If you make them stay home, are you obligated to pay regular wages? And I'm not sure if that was answered. If it was, I missed it. Sorry?
So the question, if somebody is required to self-quarantine because they put themselves in harm's way because of conduct outside the workplace that put them in close contact with COVID, you have to pay. The simple answer is probably not. But there's a couple of issues. One, if they do actually test positive, or if they do develop symptoms and they are seeking medical attention, now they are self-quarantining under medical guidance, and the FFCRA sick pay leave may creep in. So you may have an obligation under the FFCRA to pay up to 80 hours if that has not already been exhausted. If not, work from home could be unpaid, but a lot of libraries have policies in place, board resolutions that say we're going to pay employees if they're self-quarantining, or we're going to pay them regardless. And if you have that policy in place through the board, you need, I think, to take a look at that and see if there's a carve out for employees that took it upon themselves. So, and do you ever thought about that with a board resolution?
Say that point, your point again about
well, there's a board resolution in place. Let's assume that everybody's getting paid. And then somebody puts themselves in harm's way. So now they're at home for 14 days because they were in close contact, but they took it upon themselves. Could that be an exception to a board-approved policy of paying employees?
You'll have to look at that issue with respect to a particular resolution and what the language of the resolution that's used. If you do have a resolution, I would move to have you immediately or as soon as possible revise that to give you more discretion, because I think the resolutions, the resolutions that a lot of libraries and a lot of employers frankly passed in March, we had this, we're all in it together, it's going to be temporary, we're going to keep everybody employed attitude. And so a lot of communities, I know a lot of employers, libraries said, we're going to pay our employees, we're not going to make them suffer because of this. Okay. So if you're sort of have that March, to 2020 frame of reference, I think things are going to be a little bit different now, and you might want to revisit it. It's not to say that you can't do it, but I wouldn't bind yourself into requiring it, because, as this drags on, the library's finances might change with businesses going under. Your tax base is likely going to be affected next year. Think about it. Most of the taxes were in the, library's coffers by February of last year. You have your budgets in place, and it really didn't affect it. I'm not so sure that's not going to change next year. So I would revisit it to give yourself the flexibility on that regard. And I think a lot of, unfortunately, you kind of see a lot of chatter about this issue online, whereas also in March, a lot of employees were afraid of losing their jobs. So the work from home everyone was, digging in and, at their desks. And now there's a lot of, you can see chatter and articles about how, people are kind of, there's not as much monitoring, they're doing a little bit more at home. So I think you should have a little bit more flexibility on enforcement of your policies, including whether people are paid or not for their full fare. Is that, Mike, you don't disagree with anything on that, right? I also have to have my employment lawyer fact check.
No, I think that's exactly right.
I wanted to kind of ask something here about all this. So like I said, I've gotten quite a few questions about this idea of employees doing things outside of the workplace, and I think that you have to be a little careful about the word exposed. Because there is a difference. One of the things I asked someone was, if you want to furlough or send home an employee who, was on social media, say, out without a mask, with a couple people, then, and you don't know what the circumstances surrounding that picture was. Maybe they took their mask off right before they took the picture and put it back on. Maybe the people with them are relatives. I mean, there could be some variables there. According to the CDC, exposed means that you were 6 feet or less in contact with someone who is diagnosed with COVID, and that contact was a cumulative 15 minutes or more. So going to the grocery store with other people does not count as contact, as exposed. So arguably, being, standing and looking at Christmas lights outside next to 1 or 2 people is not necessarily exposed. In terms of, the CDC would not recommend a 14-day quarantine for that. Being in a crowded bar is a different situation. So one of the things I asked the person was, well, what if you have an employee who has family visit them for the holidays from out of state? or you have an employee that goes out of state. So are you going to apply the same policy to those people as you're applying to this person on social media who was standing next to a couple presumed strangers? So that's just something that I wanted to bring up, is that, you know, people keep saying the word exposed, and exposed doesn't mean that you were with a couple people. Exposed really means that you were with someone who was diagnosed with COVID. So I think part of it is, you know, you have to kind of look at the real risk, right?
Yeah, I think that's an excellent point, Claire, because the CDC, does make it clear that, it's only if you're in close contact, the 6 feet for 15 minutes. Now, they did update that a month or so ago to say 15 minutes doesn't have to be continuous. It can be 15 minutes over a 48-hour period. How anybody is going to figure that out, I have no idea. So I think that's your point is well taken, that just because you see somebody out, now you're going to require that they self-quarantine. They're probably not required to be self-quarantining under CDC guidelines. They're now required to be away from work for 14 days because of the libraries controlling their off-work conduct. So really, you're putting yourself in the place of enforcing through employment action what is the safeguards for COVID implemented by the HHS. And I'm not sure that that's a proper role for libraries or any employer to perform.
Yeah,
and you'd have to enforce it across the board. You can't enforce
That's
it
correct.
to someone who's out with a friend and not enforce it to an employee who has relatives over for Christmas.
I totally agree. Plus, you better know kind of what the rules are too. For example, my daughter is serving at her the last day of her second quarantine from being a close contact with someone in her elementary school class. I specifically asked the health department when they called me, we live with her. She's the close contact. Do we have to quarantine then too? And they said no. So, if I'm on Facebook saying my daughter's quarantined and then my employer makes me quarantine because she's quarantined, that's not correct. And so you got to be really careful about this, because it's going to matter, and it needs to be enforced across the board. If you make someone who goes to Florida, for example, quarantine because you think Florida's a hot spot, but someone goes to Colorado, and you don't make them quarantine. I mean, a lot of this is going to look very subjective. So just be very careful. If you decide to do that, it should be reviewed, by your labor attorney.
Right. I always say that too. And the CDC actually has a really good under the workplace guidance, has a really good Q&A that really goes into this and explains the idea of exposure. And if you're exposed to somebody who's exposed, you're not considered exposed.
Right.
And if you're exposed to someone with symptoms, you're not considered exposed. So it really is, like you said, it's good to, and all of this is linked. We have all of this linked on the document we have for the director's call. All of these guidances are linked on there to make it easy to find. I'm sorry, Mike, go ahead.
No, I absolutely agree with that. The one comment on the CDC's website, I would just caution, and it's excellent. I agree, Claire, it's absolutely excellent. But I would get in it through the links that, Claire has provided or that I've provided. And the reason for that is if you just Google CDC guidelines and you get into guidance, you're going to need to look at the dates.
Yeah.
Because there's a lot of outdated information out there. And you may be looking at a CDC guidance that says XYZ. And if you follow that, that may have changed. So I think anything that is more than a month and a half old is no longer valid.
Okay, we have 5 more minutes. So I think we have time for one more question. Anybody? No? Anne or Mike, is there anything that you would like to say? Anything you want to put out there?
No, just as always, we really appreciate the opportunity, Claire, to talk with, libraries about these issues. It's important, that we do this. So I appreciate your invitation for us today.
Yeah, absolutely. I really appreciate it. And
well, everyone, thank you. There will be a video recording, so you'll be able to have this and re-listen to it if you missed anything. And again, I'd like to thank Anne and Mike, and I hope y'all have a really good rest of your day. So thanks a lot. Take care, everybody.
bye-bye.
Bye.
Bye.